At this time, we're going to hear from Mike Calucci, an attorney with Olenn and Penza, who often represents police officers during the LEOBoR proceedings. So, Mr. Calucci, you can proceed, please.
Thank you very much, Mr. Chairman and members of the panel. It's funny. I feel like I'm in a case with Vinny today, and I'm going to try to avoid rebutting everything he said, but many of the things I'll talk about today will, in fact, do that. I hate to admit that I do have over 30 years now doing this type of work, and I hope to bring some of that perspective to you the way Mr. Ragasta has. I did live through the 95 amendment to this provision, and can say unabashedly that since then, with the tweaks and fine-tuning from the 80 and early 80s revision, it has been working in a very smooth fashion. And one thing I hope you never forget, that the commission study did with the 95 amendments found that 94% of cases are resolved short of a LEOBoR hearing. And in my 30 years, 31, 32 now, that has not changed. In fact, I think the number has risen. The numbers of hearings have gone down dramatically because the LEOBoR does have teeth. Mr. Ragasta laid out years of misdeeds and misconduct committed by police officers. I could spend the afternoon talking about heroic deeds done by police officers. We all know that. But all that means is there needs to be a disciplinary procedure in place. And there is. And I want to address today some of the main areas that I know the panel is concerned with, but I also want to make some general comments that I hope to use my experience on. First one is, what is LEOBoR? Okay, it's the sole and exclusive remedy for dealing with police officer misconduct. And right off the bat, you should realize that equals less courtroom litigation. This is their shot. This is where they have to do it. Okay? Specifically, it is a procedure for conducting an investigation and for conducting a hearing. That's what it is. What it's not, and this is key, LEOBoR is not a training program, and it's not a substitute for rules and regulations. It doesn't even come into play until an officer has been alleged to have committed a wrongdoing. So, in many ways, looking to change it, do away with it, it's not going to address the concerns that many throughout the country are having right now. So, and that's a key issue, because it's not a substitute for rules and regs or training. It just comes into play after there's an allegation of wrongdoing. So it's not going to address, whatever you end up doing in our legislature, it's not going to address the things that are the hot buttons of today. Okay? LEOBoR is a deterrent. I can tell you that. LEOBoR is a deterrent. It's worked in that fashion. But depending on the changes made, what I would hate to see is that we ruin something that has been working well for 30 plus years now. So, LEOBoR, as it has been fine-tuned in 1995, I think it's achieved its goal for providing a fair and uniform procedure and an exclusive and efficient procedure. What do I mean by that? Fair. It has removed much of the politics involved in the punishments of the old days. Whether you go back into the 60s and 70s, for those old enough to remember it, you'd see a policeman walking the beat because he looked at the chief in the wrong way. And there were plenty of jokes made, but all jokes are based on truth in many regards. So, fair, take the politics out. Uniform and exclusive remedy, it's the same way throughout the state. We all know what we're dealing with. Efficient. Because it's not in the courts, but for rare circumstances, there is very little litigation in the courtrooms regarding this. That means less cost. That means less time. Typical cases in a superior court in this state, 3.5 years. LEOBoR case theoretically is done within 6 months. Okay, it can be even quicker if the parties are all ready for it. You cannot get that in the courts. And To eliminate LEOBoR drastically changes protections. It would make these concerns worse. You'd have increased litigation, you'd have increased lawsuits. That means more money on the part of the municipality, more money on the part of the officers. You know, the officers pay out of pocket in most instances now. And I think it was mentioned earlier by Vinny, the Loudermill case. He's absolutely right. All public sector contract employees have a right to a full-fledged hearing at some point. The preliminary hearing is quick, but they then have a right to a full-fledged hearing with evidence, witnesses, and what have you, and that takes the form of arbitration, which again is a much more involved process, increased time, increased expense. To try and get good arbitrators now, you might get one to make an appointment for 6 months from now. So that's kind of the legal side. On the human side, what I've seen over the years, and I think Mr. Vincent, we've kind of discussed this at hearings in the past, minority recruitment has never been better. And I think the police chiefs that have spoken to you can attest to this. Minority recruitment in recent history has never been better. Diversity on our police departments has never been higher. Here's the flip side of that. These fine officers are the ones with the least seniority. So if politics makes its way back into the disciplinary process, something LEOBoR was designed to and effectively checked, it's these officers that may be affected the worst and may be at the greatest risk. Now, that's kind of my general statement. I did want to address some of the key issues I know the panel has been discussing. One of them has been increasing the summary punishment rule. Currently 2 days. Chief can summarily suspend without pay any officer. And to increase that can be a very expensive proposition to a policeman. On average, you take a 10-year or so policeman with overtime included, depending on their rank. They could be averaging anywhere between $300 or $400 a day of pay. So you're talking at present, even with the minimum suspension, that's $600 to $800 right out of their pocket, let alone inability to work any additional overtime. 10 days, you're talking $3,000 to $4,000. That's a very significant penalty without the opportunity to have a hearing. Now, on the flip side of that, by increasing that level of summary punishment, that's going to decrease that 94% number from the 95 study, and it's going to make it much more likely to increase because there's a grievance procedure that all departments have where you can grieve a summary punishment. There we go back to arbitration. Increased time, increased money. So the likelihood of, 2 days is as tough as it is to lose $600 to $800. It's oftentimes, and the statistics have shown, the officer will take his lumps, and move on. Okay, and most do without filing a grievance. I can count on one hand the number of grievances that have been filed over 2-day summary punishments. I can't remember the last one. Now, the second issue you were discussing today about the makeup of the panel, whether to increase its size or change its makeup, I can say from experience, when you start including non-police officers on the panel, there's an immediate impact. The immediate impact is increase in the number of hearing days and increase in the costs to both sides. Why is that? Because the panel as it's currently made up, they are all experts in the profession. And most of them, and I think Vinny would agree, they are seasoned police officers, most of high rank, and most with 20 plus years of experience. What does that mean? What that means is neither Vinny or I need to spend time bringing expert witnesses in to the proceeding, like we have to do in a courtroom scenario where we have delayed jurors. You don't get policemen on jurors in police misconduct cases. So we have to bring experts in to teach these lay jurors what the standards are, what the training techniques are, and that takes days, and that takes a lot of money. Okay, But with a panel of policemen, you don't need to do that. They already know the standards. They already know the techniques. They already know the industry. What else does that mean? We don't have to teach them. Well, the secondary impact because of that is we all lose the, and I'll keep it clean, the don't BS me concept, okay? You're not going to BS a panel of 3 veteran policemen as to what took place in the incident, okay? Why? Because they've seen it all, they've heard it all, so forget the BS concept. But what it also allows for is a more perspective and understanding in how certain mistakes in policing are made and how they are best punished. That's why the panel has made up how police mistakes are made, how they are best punishment. It's punishment without bias, punishment without the vengeance that was especially apropos today. The need for a pound of flesh has never been higher right now. That ought not take place in with a hearing panel deciding a man or woman's profession and their fate. So rather, with the panel we have now, they can properly decide, was the misconduct understandable in that we should save this police officer? Don't forget, a highly trained asset of the department. Or was it not reasonable so that they should be terminated? And mark my words, these panel officers are not hesitant to terminate someone when they believe it should be. And if you spoke to any of the police chiefs recently, there have been more terminations than less. Okay? So, and I think Mr. Capezza might have mentioned about the other professions. Absolutely. Doctors, nurses, dentists, engineers, accountants, judges, lawyers. They're all judged by other members of the profession much for this same reason. Because, look, you get rid of the BS factor and you get right to the things that would otherwise require expert testimony for the teaching end of it. We don't need to do that. So the way we have it, it takes the passion out of punishment. It takes the vengeance out. It's critical for the policing profession. You know, look at the nature of policing. We tell them and we mandate. Now, who does this in their job? You know, we tell them to go get yourself involved in someone else's personal dispute. Oftentimes hostile, oftentimes volatile, right? And we tell them, you go put yourself in the middle of that. Oftentimes requires them to put their hands on people or to use tools on people. So with that being said, it's certainly it's to expect perfection is unrealistic. But to expect them to learn from mistakes where they can be learned, that's reasonable. And that's more apt to come, in my view, from a panel made up of police officers as it's currently constituted. And again, these are veteran, high-ranking officers. Often the officer sitting in the chair is of the lower ranks in the lower years. Another issue I've heard the panel discuss is the issue, and it may be on the House side, but transparency and the need to not protect the identities of the officers involved. Well, lo and behold, in today's journal, you probably already saw it, state police probe threats of violence to Providence cops. Okay, police, they're looking to post on social media that share the addresses of at least 3 officers in the Providence department. Now, that's dangerous. The need to protect identities, just like sources and methods, is not new. It's backed up by the First Circuit, in our circuit that governs the state of Rhode Island, 2007, Puerto Rico versus the United States. In that case, which is still good law today, said that the law enforcement officer's privilege protects not only sources and methods, but has to protect the officer's identity. As that case said, public disclosure of names of agents and law enforcement personnel could subject them to embarrassment and harassment in the conduct of their official duties and personal affairs. That's in today's paper, okay? They ought not to be put in that position, especially when everyone is presumed innocent at first. So that case out of the Puerto Rico in our circuit also was recently followed 2018 in a case presently pending in this state, Ruiz versus the state of Rhode Island. General, I'm working with some of your people on that case. So the reasons are obvious and never more applicable than right now. The crowd, look, we all know the crowd is not always patient, and that's understandable. That's why we leave it, and LEOBoR left it to a panel of 3 policemen. Too often the crowd wants immediate recourse, and, officer safety. To burn an empty police cruiser, as terrible as that is one thing. To burn an officer's home or property is a totally unacceptable and a totally different thing. So, when the officer takes off his uniform and goes home at night, he has a family and kids, a wife and kids or whatever. And so that balance for the need for immediate disclosure of the identity of an officer versus the risk of harm to that officer or her family or their property is really something for serious consideration. It's there now. It has been protected since LEOBoR has been in place, and that should not be disturbed under any consequences. It's probably unconstitutional in the end anyway, or subject to challenge because of the Circuit Court opinions and the U.S. Supreme Court opinions. So, one final point I did want to make is we all know that it's the unintended consequences of good intentions, and there's no doubt in my mind that everyone involved on both sides of the chamber have good intentions. But are there unintended consequences that could flow? There's the old saying, if it ain't broke, don't fix it. I don't believe it's broken. I don't believe LEOBoR or statutes like it are the cause for some of the more egregious conduct that has become quite public in the recent months and over the last year. There's really no connection. There's no nexus between it. It's like I said, LEOBoR doesn't come into play until after someone has done something. So, and the other unintended consequence, which is dangerous for the public, is if it comes to where a policeman is feeling unprotected from or at risk for unjustified or unchecked discipline, what's the natural response going to be? The natural response is going to be to do very little or do much less, okay? We don't want policemen sitting in their cars, hiding out. We want them out there doing what we train and pay them to do. So, if that happens, and we see it in some other cities now, let's face it, whether it's because of defunding, whether it's because of lack of city leadership behind them, there is less work being done, and that increases the risk to the public. So nobody wins in that scenario. So unintended consequences, I think the intentions are all good on everybody's part, but really 25 years since the 95 amendment, I'm going to stick with if it ain't broken, don't fix it. It's been working well. So again, I like Mr. Agasta. I'm here if you want to ask any questions. I don't know if I can be any help in that regard, but I'm certainly willing to entertain. I know Mr. Bautista had something he wanted to ask Vinny and I.